Hello, everybody. We're going to give everyone just a minute to actually join the room here. So we'll give it just a couple of seconds while everybody joins. All right, seeing a couple of old friends popping in here. Come and watch this discussion today. I hope you all find this to be an interesting discussion, but I'm Adam Parks. Welcome to another Receivables Info webinar. Today, I'm here with long friend, former business partner, Mr. Neil Mastellone, who's working with Velo Law. How you doing today, Neil?
Pleasure to be with you, Adam. Doing real well, thanks.
Awesome. So for anybody who has not been as lucky as me or has not seen your recent Receivables Roundtable episode, can you tell everyone a little bit about yourself and how you get to the seat that you're in today?
Certainly. I got my start in this business, coming up now, I suppose it's 17 years ago in West Palm Beach, a company called Credit Max. And you and I actually were brokering debt sales for debt buyers and credit issuers, but also for accounts that we owned as principal. It was a real great crash course in kind of a lot of different facets to the business, a lot of different asset classes, and an opportunity to talk to a lot of people in this space that approach the business very differently. From there, I took a position as the vice president of sales for a Dallas-based debt buyer, and we were managing the buying and selling of several issuer direct flows for a few years. As we came up on 2012, late 2012, early 2013, the state-specific buyer model became quite a bit more difficult, and it seemed that between the availability of paper and the regulatory pressure affecting that availability, it made more sense to get into a space where we were doing some work on compliance consulting. So you and I founded a compliance management and consulting operation, and we ran around the country drafting policies and procedures to include things like vendor auditing and a software package that complemented the process for some of the most reputable debt buyers and agencies in our space. After that, I founded a debt buying company of my own in the Southwest, and we were buying primarily from other debt buyers in sort of a middle market role, and we were managing a network of attorneys for the purpose of litigating for liquidation. Most recently, I've been working with Velo Law. They're a Grand Rapids-based collections law firm that has an agency component to it, but we're operating in 4 states, Michigan, Indiana, Ohio, and Montana. There's an expansion plan that includes the Dakotas and a few other places, but those aren't really ready service offerings yet. Mm-hmm. And it's been an excellent opportunity to reconnect with some folks from prior roles, and as well, work with a dynamic firm that's growing and committed to growing, in the way that our industry participants would want them to.
Well, it sounds like your career has put you in the shoes of what are now your clients. And so I think that's really what we talked about on your Receivables Roundtable episode, was getting an understanding of what it's like to come from one side of the business to the other, right? To be a debt buyer, to be the secondary bank, and then to move over to the servicing side and truly understanding what your clients' needs are, or how to establish strategies on their
Sure. Yeah, I think it's been an excellent opportunity to kind of sit on the same side of the table as the client and be able to say, well, I have an appreciation for what's important to you because I've done this before. I know you, Mr. or Mrs. Client, have a way of doing this that you think is the right way to do it, and we can speak that language together. And I can tell you how our firm can help you accomplish that goal. Moreover, you might have a goal or a strategy that in a particular locality just doesn't work. And it might be a good idea to have that input from a vendor that has a local expertise that can tell you that, or that you may want to make an adjustment to your plan based on a particular nuance of a jurisdiction or a locality. And that's where that back and forth kind of collaboration is really valuable. And that process is facilitated by everybody kind of speaking the same language and thinking of things in the same terms.
Mm-hmm. Well, it's servicing partnerships versus just having servicers, right? So it's that back and forth. And I think, to the core topic today being the value of state-specific attorneys, I think that localized knowledge is a key driving factor as to why and how it is valuable, right? So working with these smaller attorneys that have an understanding of their localized jurisdiction puts the debt buyer in a position where they can increase their knowledge, because a national debt buyer is probably not all that great in Caspell, Montana, right? But an attorney who's actually operating in that area might have a little bit more expertise. I mean, honestly, I couldn't tell you a whole lot about Montana law.
Well, Montana is a unique animal. It's actually a very good place to work. But to your point, that state specific expertise and down to the local level can really help with efficiency. I use a term that I throw around a little too much, but a good vendor can save you a lot of rookie taxes, right? If you're stepping into a marketplace, you don't need to skin your knee every single time. You know, you can lean on a good service provider to give you some guidance that can save you some of those early mistakes. Local expertise, you know, can go beyond just the work that goes on within that vendor's office. I mean, very often they have a local expertise for sourcing vendors of their own.
Mhm.
Larger firms, and I'm not going to knock a large firm, but if you have a very large footprint, you may require relationships at that scale for things like service of process.
Mhm.
And that may be the right process server to service the volume and the footprint that you're servicing. But when that little jurisdiction in Montana, my guess is your Montana attorney has a better idea of who should be serving that paper.
Mhm.
And that local expertise, you know, can happen with very small things. And it can also happen on issues that will affect you at the portfolio level and on Moss.
So I think to kind of illustrate the point a little bit, we should talk a little bit about how attorneys were engaged when we were back at Credit Max, right? And so I think kind of understanding that expertise of the local jurisdictions can be illustrated by understanding kind of the business model that Credit Max had and how they were reselling ultimately to these state level attorneys. You want to walk us through a little bit of kind of what that business model was and how it accentuated the expertise?
Yeah, I'd be happy to. So the majority of the buyers for the state specific pools that we were selling were themselves attorneys,
Mhm.
or they had a pre-planned strategy to pursue litigation, and for obvious reasons, right? An attorney typically has authority to operate in a particular state or a collection of states, and so a state specific buy is generally a good way for them to segment portfolios.
Mhm.
What we found was these firms had an ability to use their local expertise in the absence of client restrictions,
Mhm.
right? That they could pursue the paper in whatever way they thought was best,
Mhm.
and because they were buying it as a portfolio, it was very easy for them to think of it at the portfolio level.
Mhm.
Whereas if you're buying it as an investor and placing it with a law firm that's just going to think of it as one claim after another instead of a portfolio, there's a disconnect in the communication, and that you might feel that in the performance. But when this law firm or this attorney is buying the portfolio, managing it as portfolio through their business operation that they should know better than anyone, yeah, I think their results are going to be better than someone who's trying to use their office as a tool,
Yeah.
if that makes sense.
Well, I think if you go all the way back to like what was the actual Credit Max business model, right? And so their model was to buy the accounts at 180 days past charge off, right? Mostly from a major US bank that no longer sells debt. Those accounts would then be worked through the agency network for 180 days with no litigation of any kind, and then sold in the open marketplace. Originally, they were really trying to do it on a zip code level, but that just was not a realistic breakdown. Right, it was too finite. The state level seemed to really be, in a few states, being broken into regions. But that was really kind of the business model. And the consumer attorney or the collection attorneys were able to come in and work those accounts through their own debt buying entities and ultimately become their own clients. So they can make their own investment decisions about service level agreements. They can make their own decisions about where and how they want to invest their court costs, where and how they wanted to manage documentation. Now, back in 2006, 2007, I think it was a little bit of a different animal when it came to documentation and some of the other requirements, right? Like our industry has significantly evolved in the last 17 years. I don't think anybody can deny that, at least not with a straight face. So like I feel like at that point in time, those transactions were a little bit easier. CreditMax had a digital system by which they were executing on that, right? So they had this state level auction system and they were working on kind of bids and buys and those types of things. They felt like they were a little bit more of an exchange probably than the volume they were selling really allowed for. But I think the driving point here is that the some of the parts was worth more than the whole, right? So by taking that portfolio after it had been collected for 180 days and selling it as a whole portfolio had a value of X. But breaking that up on a state level and allowing that state level expertise to shine through, those state level attorneys were willing to pay more for purchasing a portfolio because they had a higher expectation of their ability to liquidate once the portfolio was in their hands. And I think that's where that kind of that dynamic came from, right? It was they were able to drive it up. So when you looked at the sum of all of the states, it was X plus 15-20%. So the portfolios were significantly more valuable to those with that localized expertise. And for me, that was an illustrative point at the very beginning of my receivables career that really drove it home for me. I think that the attorneys always just feel like they can do better without a client restriction, right? When they're not being told what to do and they can maximize the value of their own investment, it seems to be a pretty good model. And I think there were a lot of great debt buying organizations that were being operated on a state or regional level because they were being run by these attorneys that had a significant level of expertise. Now, I don't feel like I see the same volume of small debt buyers out there. And there was a couple of different things I think that happened across the industry that invoked that change. And for me, and I know you talked a little bit about kind of the beginning of the GLBA, but for me, it was almost, I started to see the disappearance of that state level network when HSBC sold their credit card portfolio to Capital One. Right, HSBC represented, whether it be their credit card portfolio or their power sports portfolio, represented a lot of the accounts that were available for sale on a state level basis. And I think once you kind of hit a point there where that portfolio was going to dry up, we saw that there was going to be some limitations to the marketplace. Look, I was a broker at the time, right? I was at Sterling Capital Management when that when that event happened, and it kind of pushed on me a little bit to move into other areas of the business because I saw that that marketplace was going to constrict pretty exponentially. Can you think of any other major events that were kind of a driving factor in the disappearance? I mean, obviously the consent orders that came from the CFPB at its birth, specifically, barring debt sales, I'm sure had an effect as well.
Yeah, I was going to make reference specifically to those consent orders. The HSBC Capital One portfolio move wasn't as much of a red flag to me. I was accustomed to seeing people recapitalize and move portfolio around quite a bit. I didn't immediately translate that to a drought of available paper, but when it starts to come from the government and they're advising on this or that, then it's pretty obvious that those sellers are going to take that advice to heart. Mm-hmm. And they did. And I think that a lot of the folks that were making those buys at the time, like you were alluding to earlier, started looking over the marketplace and seeing, maybe there's a better place to put my effort. Some of them have beefed up their servicing capabilities and have, some more gracefully than others made the transition into servicing paper exclusively. But yeah, it would be right around the time of those consent orders that I would say that I saw that market becoming much more difficult.
Agreed. And I think as after the HSBC sale to Cap One, I think there were other indicators out there of kind of contracting paper. And I think the age of the average portfolio that was being sold started to get a little bit older. You could see that the paper had been in the market for for a longer period of time. But back to kind of our core point here was when we talk about these attorneys, being a little bit better at it. Some of the things that we've talked about previously in terms of overall kind of value drivers has been the control over the timing was kind of a big one. When do I
Yep.
want to invest in actually litigating on this portfolio? Have you seen any, from your side, have you seen any difference in how much maybe non-legal calls are being made prior to when an attorney owns the portfolio, or did you find that they tend to move straight into the litigation?
So, I would say it's closer to the latter. I think that my experience, and again, strategies differ from firm to firm, but my experience is that collection attorneys want to litigate.
Mhm.
And if there's some value in making some attempts to call, they'll make those attempts. But I don't think anyone is modeling liquidation based on that effort. I think it's just it's covering a base. I think they're planning on liquidating through the litigation process. Anything that comes through voluntarily or as a result of lettering or some other channel of communication, I think, is largely thought of as found money. It
Yeah.
might serve to offset some court costs. And again, this is if you have a firm that's able to adopt that portfolio view with you, which isn't always necessary. I mean, provided you're managing it well enough from your own desk.
Fair. I think when we look at the kind of the controlling of that timing, for me, it's been about, when do I want to make that investment, right? When and how should I outlay money, good money after bad money? I think it's kind of the age-old adage, as we kind of look at those investments. But one of the other areas we talked about was the investment itself, right? The attorneys tend to have access to investment capital to deploy for these things. And prior to I'm going to say the application, or really the prevalence of some of these specialty financing companies, right? The debt buyer financing options that have kind of grown over the years. But prior to those, I think on a state level, and when portfolios were available to be broken up like that, there was less of an investment required. And so it was a little bit easier to do private funding and to maintain control over that capital versus having to go out, borrow money, and try and have more of a margin type investment.
I would agree with that. And then another factor that can't be discounted, right, is that entire contingency fee
Mhm.
is staying at the law firm
Mhm.
that this attorney owns. So depending on what that rate is, that can materially impacts what you might think of as gross liquidation, which should materially impact what you could support as a purchase price. I don't know that anyone is jumping up and down saying, I need to pay more. I'm making so much more money on this portfolio than everyone else is, but it should have an impact on your tolerances.
Mhm. Agreed. And then from a resource management standpoint, I mean, you're like, you bring up a good point that they're never going to be negotiating with themselves for fees, right? Like it's not going to be not going to negotiate with my own company, and I don't really have to worry about fee compression, right? Which is something that the industry has experienced a lot of in the last 17 years. But with less fee compression when you're your own client, a little bit more control, and like we talked about, the management of the underlying resources themselves, right? When you can control whether it be the process service, who you're using, how you're using it, how you're applying those resources internally, and how ultimately you're prioritizing work. I know when we were, years ago, when we look at selecting agencies, we would always we would always have in the back of our mind that there was some level of a discount to those organizations that also purchase their own debt. If I was looking at a law firm, they were also a debt buyer, I always concerned myself with, am I going to get the best resources? Right? Are they going to put the best resources on the accounts that they own, or are they going to put the resources on the accounts that I own? And I think that comes down to individual law firms and management. It was always just something that was kind of in the back of my mind as I was going through that kind of vendor management and selection process.
So I think that is a problem that doesn't evaporate in the absence of a law firm that purchases, right? I think anytime you're a client of the firm, or of any firm that is, there is a prioritization of work that's going on in that firm, and a client would be right to wonder where they are on that priority list, right? And that speaks to the need to right size your vendor selection, but it's definitely a concern that's founded. Am I a priority at this organization? Am I getting the effort that I should be?
Mhm.
For the kind of work that and am I right for these guys? And that could, and then not necessarily a failing of that vendor. Have I selected correctly?
Mhm.
You know, that's a question. And maybe on their side, there's some client vetting that should be done. Are we going to do a good job for this person based on the way they operate, rather than come one, come all, which is very tempting.
It is very tempting to accept all work that's sent to you, but very smart to specifically select the work of those partnerships that you know will be successful. People do
Yeah.
business with the people they like. I don't know how else to say that.
Well, it's been my experience. And I'll qualify that by saying I tend to like those people that perform well consistently. But
Sure.
but I would agree with that.
I do, because it's a very true statement, right? Those that perform are going to tend to have a better, or you're gonna like them a little bit more because you're all performing together. But that performance generally comes from an ease of working together, right? From an ability to partner, to work together. So we tend to be successful. And I think that when you're feeling that success, it can snowball quite quickly and quite positively. When we talk about kind of these collection attorneys and why we want to look at them on kind of a state level and what's that real value, let's talk a little bit about some of the value attributes in this area. I know one of the things we've talked about in the past is setting state specific strategies, right? I like where you're operating across all these different states. I'm assuming that you're not walking out and saying, oh, well, this is the one size fits all strategy for all of our states. Here you go. Right? There's got to be some customization levels to even if the same client is using it across all of these jurisdictions. What are you seeing in terms of customization? Like,
Oh my
enhanced
goodness.
focus on
So
individual states. Now, I don't want to get too down into the laws of your individual states, but I'm looking more a little bit strategically. You can use examples.
absolutely. Well, with respect to customization, you're going to see it take a few different forms. Do I operate, and I'm speaking as a law firm, do I operate differently in one state than another? Well, of course, that's not a very intelligent thing to say, but as a result of that, and the processes and the procedures within each state being different, yeah, I need to develop different processes and procedures within my office to make sure that I'm doing those things efficiently. I can't just apply one methodology to everything and expect that if it's efficient here, it's also going to be efficient there.
Mhm.
There are some places that lend themselves to efficiency far more than others. For example, we were talking about Montana earlier. Montana is a very efficient place to collect debt. Not a lot of debtors there, but it's a particularly efficient place just based on the processes. If
Mhm.
you drive quite a bit further east and go to Ohio, it doesn't lend itself to that level of organization.
Mhm.
There's still a need to organize it, but it's going to be quite a bit more difficult, right? And it's going to be a different type of organization. It's got to be far more fluid.
Mhm.
Um, so understanding that at the local level, who's going to understand that best? Someone who's, marinating in it all day.
Mhm.
Um, so I think that, the strategy from one jurisdiction to another, and I'll just say state level jurisdiction, is going to change your internal processes, but it's also going to change what's required from your client in terms of documentation, their level of what I'll just say post-placement involvement
Mhm.
in the account. Are going to require affidavits? Are you going to, can I get a judgment without too much client involvement, or are they going to have to be involved every step of the way here? That's going to differ from state to state, and then within each state, sometimes from asset class to asset class. So yeah, I think that there's a lot of customization that needs to go on within the office, almost absent of the client's expectations. And then as soon as now you're going to layer on this need to interact with the client, those bridges need to be built between what makes them efficient and what makes you efficient.
Do you have a lot of clients that reach out to you prior to purchasing a portfolio to kind of validate some of their opinions and thoughts on an investment that they may be considering? So for example, if somebody was looking to purchase a Montana auto portfolio, might they come to you in advance and have a discussion about the documentation required? And does this portfolio meet this documentation requirement?
Yeah, yeah, and that's an invaluable part of the process. Is really one of the things you can do. Again, providing you're doing this selection correctly, is you can really lean on these vendors and ask them, look, you're the one that has to get this judgment. These are the docs that they're going to provide with me when I make this purchase. Is that going to work? Am I going to have to go back to this seller each and every time for something? Or am I only going to have to go back to this seller in the event that something catches fire?
Yeah.
And that's a very different evaluation process, right? Because it's a little harder to capture in your purchase price, but it is going to be a burden on your people and all your post acquisition work. The more of that there is, it's putting downward pressure on the kind of pricing you can support, really. And it's putting downward pressure on the value of that asset.
Agreed wholeheartedly. I mean, both from an asset perspective and from an investment perspective. I mean, the more that the more work it's gonna take, the less you can ultimately afford to pay for a portfolio. And so if you're not gonna have the right documentation, I mean, I feel like you don't hear the same kind of stories that you heard from 10+ years ago about, buying a bad portfolio. I feel like at this point, most people are getting out in front of their purchases and have a much better understanding of what they're going to do with it once they own it. A little less cowboy, and a little bit more focused, especially when it comes to documentation and with the expectation of litigation of any kind. Like the call and collect has changed, right? With the
Sure.
with Reg F and everything else that's kind of come around that. There's limitations in the communications. We may have more channels, but we're limited in the number of attempts. So I think litigation becomes a more realistic option or necessary option for a lot of portfolios to reach a realistic return on investment, which requires a longer time period. You're stretching out these liquidation rates. And with the current rise, I think I saw an article yesterday with Inside Arm talking about credit card defaults reaching all-time highs. I think that there's an influx of volume that's going to be coming into the space. And when that influx of volume does start to arrive, how are we going to manage it? Because if we go back and we look at, not that we had been in the industry for 100 years in 2008, but I feel like we had our eyes open 2008, 9, 10, 11, 12, right? As all of this industry was really evolving, we were there with our eyes open. And it does feel like there's going to be some challenges on the consumer side, right? With this decrease in savings levels, right? Increase in debt levels. And as that starts to come to fruition, and with the limitations on contactability and things of that nature, I don't know that there's going to be a lot of other options. Leveraging litigation and truly understanding the state level expertise that ultimately is required, I think is going to become an even more essential part of the overall recovery ecosystem for a time. I don't see it being able to go any other way.
So I would agree. I mean, of course, the representative from the law firm agrees, but I think that you're going to be dealing with a consumer that has a lower relative wherewithal, or maybe just a perceived wherewithal to make those payments. And if you're going to limit your ability to solicit those payments, I mean, those are two distinct downward pressures on your gross liquidation numbers. Where I think you'll see some major uptick there is a litigation strategy, like you're deciding, but like you're suggesting. But that's going to require a secondary investment in the form of court costs. And so that has to be done in a disciplined fashion. And I think there the vendor management piece becomes very important. And suit selection is key there, right? Because you can't just be spraying and praying and suing each and every person and hoping that will somehow result in an economically efficient level of portfolio management. And we've been shown time and time again, it does not work that way. So the level that you need to involve that vendor in the suit decisioning, is going to differ based on your model, based on how you typically go to market. It's also going to vary based on your anticipated suit penetration, right? If you're buying a portfolio and you're only planning to sue the very most liquidable 3 or 5% of that portfolio, there's a lot of firms that can do a very good job of that for you, because you're gonna send them, accounts that are very simple to work with. If, on the other hand, the strategy is sue 40 or 50 or more percent deep into this file, well, then the stratifications and the performance of those firms become a lot more clear. And the need to involve them in the decision-making process. I see more value in involving them in the decision-making process for those suits as the suit penetration grows. There are buyers and the managers of networks that say, well, no, that is our whole value to the investment, is that we're making that decision. And, I'm certainly respectful of that as well. And a good firm should be able to operate under both sets of circumstances.
I think there's a lot of different strategies by which an investment, can be made into the space. But one of the things that we've talked a little bit about it's called the getting of the suit itself, right? Like going after and obtaining the judgment itself. But I would think that the state level expertise would extend beyond that and into the actual enforcement of these judgments, with each state having different rules and regulations and procedures and processes related to actually executing or enforcing one of these judgments, to actually turn that piece of paper into dollars that for the client is going to be a major factor. I mean, even just within the states in which you guys are operating, I would think that your enforcement mechanisms would be quite different.
Certainly. And as well, the time frames, excuse me, the mechanisms for enforcement and the procedures then that are by extension, the procedures you have to follow to enforce are going to differ from jurisdiction to jurisdiction. And the closer you are to that process on a day-to-day, you ought to be continually evaluating whether or not you're doing that in the right way. If you're any kind of business person, trying to make sure that your resources are being applied in the most efficient way possible. And if you're properly aligned with your client, which, sometimes that's a bigger if than others, but if you've done the upfront work and you are properly aligned with your client, what's good for you is good for them. So the more efficient you can make yourself as an operation, they should feel that efficiency. Not every cost savings is an efficiency. I'll qualify that, but where you make yourself more efficient, your client should feel that efficiency.
Even from a strategic standpoint, when it comes to the enforcement, right? Knowing that in this state, I'm going to go after wage garnishments, and in that state, I'm, trying to lien homes or whatever the case may be, right across those different jurisdictions in which you're working, being able to help the organization or the investor, debt buyer, creditor, understand, the value attributes there and help to set that strategy on a state by state basis. I know when we talked on our receivables roundtable episode, you talked a little bit about like maintaining and managing expectations of the clients, right? And
Sure.
setting reasonable expectations for them so that you are always successful. Can you talk a little bit about, how you're helping to, or how you're communicating, helping to communicate and manage those expectations and put them on the right path towards success, right? Success is relative to what their expectation was.
Certainly. So I think that you can manage expectations best by outlining upfront what it is the client is after. What do they see as success? Very often, a sophisticated client will come to you with a set of work processes, and your ability to follow those processes is what makes you successful. It's not so much that you're doing such a great job, it's that you're doing what we're asking you to do. And that's one relationship, right? And if that's it, if you want this firm to literally just be an extension of your intelligence and operations, then that's one firm. Laying out expectations for time frames, I think is probably one of the best things you can do for new clients. I think that very often what can happen at a certain speed in one jurisdiction may not happen as easily in another. And as people are moving into new states, perhaps reclarifying some of those expectations is worthwhile. there are also national outfits that have been operating in 50 states and have a very good set of tight controls over what they're doing in all those states. And a new vendor is being onboarded to see if perhaps performance would be a little bit better, or if they can better work within that system. And if that's the goal of the client, well, that's one way that that vendor has to go to work, right? If on the other hand, that that client is leaning on the vendor, and I say leaning, but relying on that vendor to do a lot of the address location and to do all of the skip tracing waterfalls, all the POE, and all those things to decide who, what, and when for filing suit and pursuing post-judgment remedies. If they're relying on the firm to determine when all that happens, well, then you certainly should be letting that client know what you expect as far as timeframes go. Well, if you're relying on me to do it, this is how I'm going to do it. And based on those timeframes, is that acceptable? I can make certain changes, right? I can do things differently in certain ways. Can't do everything. I can't make a process that takes 30 days take a day, but within reason, I can try to work in a way that works better for you. If you're that client that, again, is going to be relying on the firm for a little bit more of that intelligence and decisioning.
Well, I think, we talked a little bit about competency, and the differences between, let's say, a law firm that is authorized to work in a jurisdiction and one that is competent in the jurisdiction, right? And so just being able to work in a location does not necessarily mean that you should work in that location. What has that experience been like for you?
So it's a mixed bag. I think that there are people that have an ability to work in more states than just the state they're in, and that ability is, I want to say ceremonial, but they just, yes, sure, I could work there. Do they work there? Is it a part of the business that even makes sense for them to develop a real expertise around? Sometimes the answer to that question is no. Right. If, on the other hand, the ability to work in that state is part of an expansion plan into that state, and they're developing processes around that state becoming a revenue center, well, that's different. The ability to work somewhere and the ability to do a good job somewhere are very often different things. And as we were talking about earlier, it comes down in most cases to having very, very tight processes. Right. And then they don't fall out of the sky. Right. I mean, I suppose you could do some hiring in the new state and maybe piggyback on some of their knowledge and do a little of what we're talking about with the local expertise, right? As you expand into a new locality, maybe rely on some of the more local expertise that already exists there. But either way, you're going to have to develop your own, because there's got to be a reason for you to do business with me and not the guy down the street.
Yeah. Fair enough. I mean, I would also like to think that, from a competency standpoint, it's all of that expertise related to the post-judgment remedies, right? The timing of filing suits, the understanding of those individual jurisdictions. So a lot of the things that we talked about kind of throughout this process, like just being authorized to work in a location doesn't necessarily make you the right choice for the investment group.
I think, from things that are as simple as seasonality. Yeah. I mean, I think that most people would suggest that there's a seasonality to our business, and in different locales and in different jurisdictions, that seasonality is different. And just having that information or that insight might be something that drastically impacts efficiency. But again, it would be a matter of having that local expertise, which you could certainly go about earning yourself. You could absolutely get into all of these marketplaces and develop this knowledge for yourself. But I think you're gonna pay a lot of rookie taxes doing that.
Well, let's go back and talk about the rookie tax for a minute, because I think that's an interesting. It's one of the Neil-isms that I'm going to be carrying forward, similar to, and I'm going to just quote this because it's my favorite Neil Mastellone quote. When we first started working together, Neil told me we were dialing, right, like we were on the phones doing deals. And Neil told me that the phone was just an ATM, and every time he put in a PIN number, sometimes it spit out money, sometimes it didn't, but he was going to keep putting in PIN numbers until it gave some money. And to me, that was always such an intelligent approach to the whole process of market making, right? And at the time, we were doing market development. It wasn't really sales. It was more getting organizations involved, finding all of these small state level debt buyers and bringing them together into a marketplace, right, to purchase those portfolios. But now you talk about this rookie tax, and I really like this one. Talk to me about what the rookie tax actually means to you.
Okay, well, I think the rookie tax is not unique to accounts receivable management. I think anytime when you go into a new space where you'd like to do a good job, or you need to learn something, or you need to perform, I think everybody goes into those spaces, or I hope everybody goes into those spaces with the best of intentions and tries to do what feels like the next right thing to do.
Mhm.
And if you've done that in earnest, you know that you weren't always right. That you tried to do what felt like the right thing to do, and sometimes you stepped on a rake. And there are people that could have told you about that rake, and but it's true. Uh,
100%. That's why I like
there are people that could have told you about that mistake, right? And had you had the foresight to say, well, I don't know, right? I'm going into this new, I'll use our industry, then this new state or this new jurisdiction, and this feels like the right thing to do. But let me ask an expert. I'm relying on this firm to do the work,
Mhm.
right? If I have that level of trust in them, shouldn't I also trust them with this? And if you can't, maybe that's a question you need to ask. Why? Why would there be a disconnect there? But yeah, I think that's something you should feel very comfortable as a client doing, as you're, whether it's new product or new jurisdictions. Lean on these folks that have the expertise and say, what don't I know? This is what I'm thinking I want to do. This is how I'm going to buy this stuff. They're going to give me these docs. I'm going to send them over to you this way. That's my plan. They might say, great, pop it on an FTP. We'll get right to work.
Mhm.
And they might take a look at that contract and tell you you're crazy if you make this deal. It was definitely worth that phone call.
Agreed wholeheartedly. Talking to the service provider prior to doing it. I mean, even in my last role sourcing deals, the first people that I went to were those in the litigation stages and said, is this a good deal? Does this make sense? Does this documentation match up? Should my liquidation expectations be realistic here? Right? Because that ultimately was kind of it's one of the three-legged pillars of debt collection, right? You always had kind of the three-legged bars where you have the debt collection, the phone calls, digital strategies, right? Like the traditional collections, you have litigation, you have debt sales. Now, for debt buyers, debt sales is not really an option the way that it was 20 years ago. So kind of leaning on those other two areas becomes exponentially more important, which also brings us to talking a little bit about the efficiencies. And one of the things, that you and I've talked about through the years is looking for efficiencies in litigation through state liquidation versus just looking at the volume. So we look at our portfolio and we say, okay, I've got the most accounts in this particular location, but is that where I'm going to find the most efficiencies, right? So breaking down those individual states and looking at the liquidation curves or the liquidation capabilities of those individual states seems to be a method for fact finding that can get you toward your solution a lot faster.
Sure, and I think that kind of modeling is really necessary in the acquisitions phase, because if you're buying a portfolio, especially if litigation is central to the liquidation strategy, which, as we point out more and more, that's going to be the case. You really have to start asking yourself, how much am I going to have to reinvest in this file?
Mm-hmm.
And from jurisdiction to jurisdiction on an account level, that's going to vary wildly. So that's going to have a lot to do with efficiency. As you start to do the ROI, the cash flow that you're discounting back has to be net of that cost investment.
Mm-hmm.
Right? So as you're calculating relative ROI on a portfolio, the footprint and what that footprint is going to cost you definitely has to go into the decisioning for acquisition. And then once you have a file, the pace at which you're litigating has to be sort of a, forgive my crudity here, sort of a bang for the buck decision,
Mhm.
wherein you're saying, well, I can sue these people in this state at $100, but if I want to sue that same kind of debtor in this other state, it's going to be $400. So perhaps my best bet is to pursue the lower cost liquidation first, and
Mhm.
then maybe be a little bit more choosy in the higher cost areas. Um,
I think that
and
makes a
again,
lot
that
of
boils
sense.
now it boils down to modeling, right? I mean, you have to have an ability to model these things as portfolios get larger, as geographic footprints differ from national population distribution, just based on where those banks are headquartered, or maybe it's a subsequent debt buyer that's not really selling you a contiguous file, it's just a smattering of paper.
Mhm.
Yeah, you really do have to do that kind of modeling to know what you're looking at.
I think the modeling is key in understanding that investment. You know, as we kind of come into our final 10 minutes here, could you talk a little bit about how our audience can be right sizing the law firms that they're working with?
Yeah. So right sizing is something I can't overstate the importance of. It seems to me that firms grow generally based on either the quality of the work they're doing or the commitment of the ownership just to grow for the sake of growth, right? And a bigger firm, sometimes it's hard to tell what drove that growth, right? So a bigger firm might not be a better firm,
Mhm.
just based on their volume, and as well, even if they're a very good firm, if they're a bigger firm, that might bump you as a client down that priority list a little bit, because where do you rank among their other clients? I think I think right sizing is really a two-way street, right? So how big is this firm? How big am I? What other clients do they work with compared to me? Am I the biggest client here? Great, I'm going to get a lot of attention. Am I the smallest guy here? I should get the same attention as everybody else, but I probably won't, right? I mean, ultimately, these are business decisions that have to be made, and shoulds are tough when it comes to that kind of thing.
Agreed.
I also think that there's a temptation to say, well, then boutique
Mhm.
firms are best. I want to be the biggest dog in that whole place. That might not be the best thing either. What if you're the best client they've ever seen,
Mhm.
and your business is like this huge leap forward in their development plan, and maybe they're not ready for you.
Well,
They're
that
probably
that
not going to
is the next question is like if they're real small, right? Are they gonna meet the technology requirements? Right? Like, I mean, you're coming from, I think, a unique shop where, Scott Renner is a really a tech guy who is also a lawyer, right? Versus a lot of lawyers who hire a bunch of tech guys around them to try and resolve these issues. So I feel like there's right size is the right term for the situation because too big gets you diluted and lost in the shuffle, and too small makes your every word or breath overreactive on their part, right? If you're the biggest client in the room, they're listening very closely to everything you say and maybe overreacting to things.
And there's also a more simplistic issue. You could just be too sophisticated for them. And salespeople and business development people, I love us, but we do have a tendency to overperform, to overpromise rather. And I think that if you're growing an organization, there's a temptation to reach toward more, and to reach toward growth. Um, and as client, you just got to make sure that's something that's happening legitimately, right? That growth and expansion at this firm are happening at a legitimate pace and as a result of performance.
Mhm.
It's difficult to get a real handle on that in the early goings of a relationship or before you actually have a working relationship. But again, that is the importance of good relationships, right?
Mhm.
So
100%. And I think as we continue to look at right sizing firms, uh, the technology will always be a challenge, right? And I think the disconnect between some of the attorney firms, tech, like underlying technology, and some of the debt buyers or banks underlying technology can be different, but through the opening of APIs, I think that's really smoothed over in the last, let's call it 5 years or so, in terms of being interconnect different systems across different platforms. Neil, as we kind of come into our final moments here, is there anything else that you would want to share with the audience about why or about the value of kind of right sizing the firms that you're working with and looking at that expertise of the state level attorneys?
Yeah, I think that the value is simple, but I think that sometimes simple things can be profound. And that is that someone who's closer to the work can have more impact on that work.
Mhm.
Someone who is working in a particular jurisdiction and is close enough to watch the changes that are happening in that jurisdiction before word gets around to everyone, that's someone that can help you a lot.
Mhm.
I think that with respect to right sizing, as it relates to state level attorneys, I think that sometimes having a firm or two or three in a state rather than one or two or three firms that are themselves servicing 6 states for you,
Mhm.
I think you're diluting some of that local expertise, right? Um, Not in each and every case, but the tendency would be there, right? If I have to operate in many more places at a much larger scale, well, by definition, I lose some of
Yes.
that finer level of control.
Yeah.
Um, and these are all decisions that you have to make based on how important to you the litigation piece is to your strategy, right? Because more involvement in that process is also going to cost you more, right? So if it's central to your strategy, then absolutely the closer you can get to local expertise, the better. If litigation is a backstop and it's if it's something that's not really the heart and soul of how you collect, maybe you have some leeway to be less selective, but I don't think so. I think you're probably always better off trying to nail down the tightest local resource.
I don't think anybody that's watching this podcast or this webinar is not looking for efficiencies in their operations. I feel like the audience that be watching us should be taking that advice and kind of continuing to look down those avenues. For those of you that are watching today or watching on the replay on YouTube, feel free to ask additional questions in the comments. We'll be answering questions on both YouTube and LinkedIn, or if you have additional topics you'd like to see us discuss, I'd love to have Neil back again. Always really enjoy an opportunity to talk with you, my friend, and to learn from your insights. I appreciate your time today.
It's really been a pleasure. I look forward to coming back.
Absolutely. For those of you that are watching, we're here to answer any questions online, but we'll see you all again soon. Thanks so much, everybody.